3, 2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Mr. Hevner. And on behalf of Judge McBrayer and Judge Golden, we welcome you to our oral argument today, which is being live streamed for public viewing. We will conduct today's hearing in the same manner as if we were all together in the courtroom. Each of you have 15 minutes to argue your case, and of course the appellant has the right to reserve some of that for rebuttal, which I understand you've already done. So unless there are any announcements, we'll ask Mr. Hevner to call the case.
Bobby Scott Smith versus Barbara Diane Smith.
Mr. Birch, you have the floor.
Thank you, Your Honor. I represent the appellant in this case, Bobby Smith. I would like to say I was not involved in this case at the trial court level, so this has been a learning experience for me as well, as far as learning how we got to where we got at the end of this case. This case was tried over the course of 4 days, and really it's a relatively simple divorce case as divorces go. I'm really not clear why it took that long over that amount of time to try this case, but there's no minor children. The issue is almost solely the division of marital property. These parties were married for some 32 years, but this case is unusual in the fact that they were separated for almost 10 years at the end of their marriage. As I stated, this case was tried over 4 days between January and October of 2018. An opinion from Judge Gwynn was entered on December 18th. A motion to alter amend was filed thereafter, and an amended decree went down from Judge Gwynn after he had already stepped down from the bench on May the 7th of 2019. And I don't believe I have ever seen two orders more different as far as the judge's findings between those two orders. And it's unclear to me exactly what happened or how much the judge could have changed his mind over the course of those some 5 months between December of 18 and May of 2019. The original findings of fact in the original decree stated that what I think is pertinent to the issues of the division of marital assets, there were some findings made such as the wife in this case had diverted some significant portion of her earnings to her mother, where she was living in a house that was owned by her mother, but part of Mr. Smith's theory was she wasn't contributing to the marital household, she was contributing to her mother's household for a significant period of time, as I stated, almost 10 years in this case. Another finding of fact was in the first original decree was the wife Judge Gwynn found that the wife had the better opportunity to acquire future capital assets. I assume that's due to the physical nature of Mr. Smith's work as a contractor, labor intensive. Both these parties are in their 50s. Miss Smith works an office job, and Mr. Smith's vocation is more physical in nature. So the court found that she had the better ability to acquire future assets. And another finding of fact, the court found that the husband's health was poor. About the only finding in the amended decree entered in May of 2019 was somehow between December of 2018 and May of 2019, the court found that the husband's credibility to be poor regarding his health and his income. The court did not point to any examples of that in its amended final decree. To my knowledge, there wasn't any proof that was taken, but somehow Judge Gwynn completely changed his opinion between December of 2018 and May of 2019. Now, I'm sure that's within Judge Gwynn's purview to change his mind if he wants to, but he really doesn't give us much analysis as far as why he did that or for what reason, or give any examples citing to the record or anything of that nature.
Mr. Birch, I'm of the impression that the principal issues on appeal pertain to the valuation of property, the division of property, and attorney's fees.
That's correct, Your Honor.
I'm not sure these facts that you've just mentioned have a lot of bearing other than credibility on those issues.
Well, I was getting that, to Your Honor. The main issue from our perspective is the division of property, particularly what I'll refer to as the Beach Log Road house. That was the home that was occupied by my client. It was built by my client through almost 100% his efforts. It was finished in, I believe, 2007, and Mrs. Smith moved out of that home in 2010. She moved in with her mother. The court found that half of that equity should be Mrs. Smith's, and it's our position that Mr. Smith, in this unusual case where they were separated for such an inordinate amount of time, he is the one that maintained that. He is the one that paid all the taxes, paid the mortgage payments. For some period of time, Mrs. Smith paid $350 per month. Mr. Smith stated that was for her cell phone, which he also was paying for, and for storage of her personal belongings in the house. Whatever the case may be, I think it's uncontested that the vast majority of the upkeep and the acquisition of the equity in the Beach Log Road house was due to my client's efforts and nothing that Ms. Smith did. The court found that Mrs. Smith diverted a significant portion of her earnings to her mother's home. And there's really not much in the record showing that she did much of anything to contribute to the equity in the Beach Log Road home. So what we were asking, rather than a 50-50 division of the Beach Log Road home, we're asking that be perhaps a 75-25, something along those lines, as far as if the court looks at each party's contribution to the equity of that piece of property. There are three smaller pieces of property, I say smaller, but less valuable parcels of property, less equity, that Mr. Smith owned with some business partners.
So how were those two pieces of property that your client claims part of the property, how were they titled? Were they titled in the individual names or in the name of a partnership?
You're talking about the three other pieces of property?
Well, I'm talking about the Kane, the Newtown Road, and
Okay.
Canesville.
Those were with partners, Your Honor.
Right, but how were those properties deeded?
I don't know exactly how they were deeded. I'm not going to guess exactly, but my impression from reading the record is that they were deeded. I believe they were deeded individually between his partner and Mr. Smith. Miss Bean may be able to speak to that better than I was, because she was counsel of record. I have some memory of that. But the main the main piece of property is the Beach Log Road property, but these other partnership properties, what I'll call them, there's no proof that Miss Smith had anything to do with those properties. And I think an example of this would be an example of how Judge Gwynn treated one thing different than the property. He found that during this period of separation, this almost 10 years, that Mr. Smith acquired approximately $60,000 worth of credit card debt. Now, admittedly, some of that is for attorney fees, and that should rightfully be his, because each party was to pay their own attorney fees. But they found that to be separate debt because it didn't benefit Ms. Smith. We think the same analysis should apply to the property. And if Ms. Smith didn't do anything to contribute to any of these properties, as far as the Beach Log home and the partnership properties, we think that should be taken into the analysis as well in the equitable division.
All right, thank you, Mr. Birch. We'll hear from you on rebuttal. Ms. Bean?
May it please the court. Melanie Bean on behalf of Ms. Diane Smith. I'll first address the issue related to the Beach Log Road property, the briefs that were submitted by both parties. The first issue appears to be that Mr. Smith is challenging the value that was selected by Judge Gwynn on the Beach Log property. I submit to the court that this is without merit and that there is no evidence in the record to preponderate against the trial court's ruling that the appropriate value that should have been selected was $510,000.
I am curious, Ms. Bean. It appears that value or the equity in it changed 3 times in the court orders. What is that about?
Judge, the first ruling made by Judge Gwynn in the original final decree that was issued December the 28th, Judge Gwynn specifically identified that he mistakenly relied upon the husband's asset and debt liability statement. His original finding was based upon the husband's original value was based upon a 5 or 6 year old, I think it was from 2015, expired insurance policy, plus what he had identified as an appropriate value for the land. So he had combined those two together. And so the equity that was placed in the husband's original asset liability statement, that's what that number was derived from. It wasn't derived from the appraisals. So when the court issued the first amended, the amended final decree, the court made a mathematical error. And that's why the second amended final decree was entered, was because the court noted that mathematical error. So the first amended decree, that was just a mathematical error. The amended.
So your position is there was no new or different evidence. It was just a mistaken reliance and a clerical error.
That is correct, Your Honor. And in fact, I submit to the court that the court did rely upon the most reliable evidence that was available. There was 4 different valuations that was submitted by Mr. Smith himself through his testimony, and I've identified those in my brief with the appropriate citations. And like I said, his value was based upon dated information and largely based upon his argument that Ms. Smith should not share in the valuation or increase in equity after 2010. And I disagree with Mr. Birch's analysis or his statement that these parties separated. They didn't separate. It is true that they did not cohabitate together as of 2010, but Judge Gwynn made multiple findings of fact. And I believe the briefs of Mr. Smith, probably unintentionally, failed to actually recognize the number of findings of fact that the trial court made when the court issued the amended final decree. Those are found in volume 5 of the record, and I cited to them heavily in my brief, pages 444 through 448. Those findings of fact largely detract from or contradict or replace the majority of the findings of fact, the minimal findings of fact that Judge Gwynn made in the original final decree. And even at this oral argument, it appears that Mr. Smith, through his counsel, is still relying upon those original findings of fact that the trial court, candidly, stated in his amended final decree. Listen, the extensive delays, I made a mistake here. I've had an opportunity to go back and look at these transcripts and look at the evidence, and I made a mistake in here, and he fell on that sword in paragraph 1, and then he issued his ruling. So the fact that at this oral argument, there's still some sort of statement that an allegation that the wife diverted a significant amount of her earnings, as stated in the original final decree, that is not what Judge Gwynn found. In fact, in his findings of fact, which are separate from the second amended final decree, specifically detracted and stated that the wife did not do that. The court specifically made a finding in number 29, finding of fact on page 448, volume 5 of the technical record, that the wife did not do that, that her mother legitimately owned that property. In fact, my client rented it for a number of years before her mother actually purchased it. So that issue in front of this court and those facts, I submit, are being relied upon without any sort of merit. But getting back to the beach log property and why the 510 value is appropriate, the increase in equity was only about $67,000 between those two numbers. And the most reliable evidence in front of the court was the joint appraisal that was the most recent valuation. The next valuation the husband submitted to the court was a 2016 tax assessment of $502,000. Every other number the husband tried to get the court to adopt was based upon much more dated information, and again tied back to his argument that the wife shouldn't share in any equity after 2010. The trial court made multiple findings of fact, also in the additional findings of fact that was listed between pages 444 and 448 of the technical record, that clearly indicate that while they live separately, they continued to have a marital relationship. They continued to have a marital relationship. They continued to visit each other. They continued to have an intimate relationship. That's what the evidence in the record indicates. Further, my client, whose net income, undisputed, is $1,700 a month. During those years that they did not cohabitate, she continued to deposit. I believe the exhibit is 81, which was also quoted by Judge Gwynn, which is the evidence in the record to support my client's continued contribution after they ceased cohabitation. She not only paid the $350 a month, she maintained the husband's health insurance as well. We're talking about a person who worked for 32 years. Her net income after 32 years of working was $1,700 a month, and almost half of which went to support the household that the husband was living in, the marital expenses, and providing him with health insurance. So with all due respect to this argument that one, beach log was inappropriately valued, the court picked the most appropriate value based upon the most recent evidence that was submitted, all submitted through husband's testimony. Two, this idea that Mr. Smith is entitled to a greater division of the marital estate is completely based upon a portion of the marital property statute, or the definition of marital property, that requires a finding first that there was separate property. They continually argue in both of their briefs that the wife did not substantially contribute to the preservation or maintainment of his businesses or these rental properties, specifically Canesville Road and Newtown property. But that requires a finding of separate property first. This was marital property all day long. And at the very beginning of my brief, I go through every one of these properties was acquired during the marriage. They were purchased with marital income. They were properly classified as marital property. They were not classified as separate property. So the sections and the cases that are relied upon by the husband in support of their argument on appeal, and quite frankly, it was the same argument that they had at trial, it's not even applicable. Wade doesn't apply. Keat doesn't apply. Neither one of those cases apply because it requires a finding of separate property first before you go into the other analysis. This idea that my client, after 32 years of marriage, who worked every day of this marriage, the homemaker, primary caretaker of these children, that somehow she's reduced to the monetary contributions that she made to this marriage, it's offensive and it's chauvinistic. And it's very offensive to me when she contributed the exact same thing the husband did. She worked, she did physical labor within her means and within what she's supposed to do. But somehow now we're supposed to reduce her back that she's not even entitled to 50% of the marital estate. You know, when this argument was advanced at trial, and another reason I want to get to the attorney's fees argument, Judge Gwynn looked at the husband and his counsel early in this trial and said, you know, I'm looking at the definition of 364121, which I have to go by. And, you know, you're going to have to demonstrate to me how that's not applicable. We go through 4 days of trial, and now we're in an appellate argument where they're still arguing case law and statutes that are not applicable to this case. And what's even more egregious is nowhere in these briefs do they demonstrate to this court any evidence in the record that would preponderate against the trial court's rulings. None. They don't present any evidence or facts to preponderate against the trial court's rulings that it's marital property or that the husband should be entitled to a greater division, or that somehow the Newtown property and the Canesville properties were misclassified as marital property. So their arguments are completely without merit. As I stated a moment ago, the fact that there's a continuation of advancing arguments at trial and on appeal that's not based in law. My client incurred $29,000 of attorney's fees at trial, which presumably will have to be paid from what she was awarded. And if you look at what she was awarded, she's going to get about $120,000 in cash assets that she gets to start over with. That's it. So you eat up the majority of that with your attorney's fees, and the husband can fire and hire attorney after attorney after attorney, and she doesn't have any choice but to defend. That's unfair. And I do submit that there was sufficient evidence in the record to preponderate against the trial court's ruling that the husband didn't have the ability to pay attorney's fees. The courts will note, where I asked the court to note, in the original final decree, when Judge Gwynn made his ruling, he originally made the finding that wife had not asked for alimony. He failed to see that there was a pleading that did assert that, I'm presuming, because when he issued his second amended final decree, he said that the husband doesn't have the ability to pay. Well, I submit to the court that there is substantial evidence in the record to demonstrate that the husband does have the ability to pay alimony, not only in income, but in assets. There is no evidence in this record that my client has the ability to acquire superior assets to the husband post-divorce. Her net income is $1,700 a month. The husband didn't even present an income and expense statement. The majority of the trial was spent disclosing to the court the fact that he failed in discovery to report his income. The Rutman property, which was discussed not in the findings of fact and discussed at trial. The Salisbury Road property, we had to bring in third-party witnesses to demonstrate the amount of income that he had. He didn't produce any of that in discovery. We had to uncover it and bring it to trial, which was credibility. So the proof at trial was not only that he had ongoing business developments, but we also showed the amount of deposits that he had at trial. And I think I quote in my brief on page 26 that his deposits from income in his bank accounts from 6 months of 2016 were equal to the wife's gross annual income, gross. And his 2017 deposits doubled the wife's gross annual income. And he hid the fact that he had ongoing business ventures with Mr. Stroud through the Salisbury Road property and the Rutman property. And the majority, and if he does keep this Beach Log Road property, he doesn't even have to borrow up to half of the equity in order to pay my client the $120,000 that she's due. So with all due respect, I believe that the court has misapplied the factors that the court is supposed to consider under 365121. Specifically, I think the court has not appropriately applied to factors 1, 3, and 11. The court did specifically note that this trial was extensive because of Mr. Smith's behavior. And I submit to this court that my client shouldn't have to bear the attorney's fees related to that out of her division of the marital estate. That should come from the husband. And I did argue in this appeal, in this brief, that this appeal was frivolous. I believe to my core that it was only filed to keep him from having to pay her that money or having to sell this property. And he has succeeded so far. Arguing case law and statutes that are inapplicable to this case. Inapplicable 100%. So with all due respect to, and I know Mr. Birch was not trial counsel and I was, so I have a little bit more information, probably sound quite more vested, don't I? I would argue, it does appear, the last thing I would say is that it appears that the husband argues section 5A of the statute, that, you know, that his contribution is somehow greater than the wife's. But what that does is ignore substantially the contributions that this wife gave, not only as a wage earner, a parent, a homemaker. Doesn't matter that she earned less. She's equal to him in the eyes of that statute. And he's not presented any evidence that would override that. Thank you.
Thank you, Ms. Bean, for your argument. We'll hear a rebuttal from Mr. Birch.
Thank you, Honor. I certainly didn't mean to come across as chauvinistic.
Well, let me ask you, Mr. Birch, is there any question that this property is marital property, that all of it was purchased during the course of the marriage?
No, Your Honor, and that's why I did not argue that. I'm not arguing that here today. I'm not arguing that any of this is separate property. I am arguing toward the what constitutes an equitable division of the property, and we simply, due to the lengthy separation, and I would take issue with Ms. Bean's characterization that these folks weren't separated for almost 10 years. At most, they had dinner a few times and had marital relations maybe once in 10 years. So for any meaningful purpose, they were separated for almost 10 years in this case. And all of the equities in the three partnership properties would have been earned during this separation, and most of the equity in the Beach Log Roadhouse was acquired during their separation. Mr. Smith maintained that property. He paid the mortgage, he paid the taxes, and without any contribution. I'm not disputing that it's marital property. I'm merely disputing that when the court looks at all the factors that are considered in the equitable division of the property, I just don't think 50-50 to each party is equitable in this situation. Do your honors have any other questions?
Hearing none. All right. Thank you, Mr. Birch and Ms. Bean, for your arguments. We will take this matter under advisement.